Contractors are very common in the early stages of startup development. They can offset costs and create capacity a startup might not otherwise have. What are some of the precautions that an entrepreneur should consider taking with IP to get the benefit while managing the risk?
There are legal precautions and then there are operational precautions. And I've talked about the legal precautions, the non-disclosure agreements, where you also can have non-compete agreements where state law permits that. It's not across the board. Some states completely disallow non-compete agreements, but there's more than one way to skin a cat usually. And then assignment agreements, great thing to get those things done up front. And then to enforce those agreements. For example, we have one inventor who's just amazingly prolific, and he's also amazingly prolific at pursuing potential business deals out, with helicopter manufacturers and others. So he generates interest. We'll have them sign an NDA prior to his disclosure of any information, prior to any visit by their engineer, and then once they've decided not to proceed, or somehow the business relationship is not going to materialize, we then require the return of all that documentation, and then we monitor for a period of time afterwards to ensure that there's compliance with the NDA. So what I mean is ongoing protections that you asked about are monitoring to ensure that the terms of the NDA are enforced. And it can be as simple as a Google search, schedule out every 3 months, do a Google search, and then follow the information down those rat holes and see if you can detect any malfeasance. And then continue that for the entire term of protection. So if the NDA gives you protection for 2 years, then you want to monitor it periodically for 2 years. And then if you find something questionable, you immediately put them on notice that they may be breaching the agreement, and you want them to come clean and tell you what's going on. So vigilance is key. That's one thing you can do. When it comes to trade secrets, that's a little bit different kettle of fish. Trade secrets are the intellectual property that you get under state law. There's one federal statute about it. Trade secrets are the things that are not protected by patent, like your customer list, for example. That's really important. And we've had that happen with clients too, where someone will work for them on a contract basis and then run off with their customer list. I mean, it's happened to me even. So it happens to a lot of us, unfortunately. So what needs to happen there is that the access to the trade secret needs to be protected. Its purpose of disclosure needs to be very clearly defined for X purpose, not for this big, broad, to further discuss business relationships. It has to be very precise, the dates on which someone can access it, when they accessed it, and it's important to keep your electronic records very clear. If you can, keep all the email on a system that you set up and control so they can't delete all their Gmail and nuke all your evidence that they've run off with your customer list. So the more you can keep control over the electronic data regarding those communications, that will also help you.